A recent article posted online by the Convention of States Project, or COS, insists that new documents uncovered reveal that the late Supreme Court Justice Antonin Scalia favored an Article 5 convention. The Scalia quote, which also appeared in an email sent by former U.S. Senator Tom Coburn to Oklahoma state legislators in order to convince them to pass a Convention of States Article 5 application, simply states, quote, "If the only way to clarify the law, if the only way to remove us from utter bondage to the Congress is to take what I think to be a minimal risk on this limited convention, then let's take it." Sound convinced? Well, before you go around posting this on social media as evidence of Scalia's alleged support for a convention of states, there is more you need to know. First thing we have to ask is, when did Scalia make the statement? According to COS's own article, Scalia said this on May 23rd of 1979 at a forum hosted by the American Enterprise Institute. This forum in which Scalia said these remarks was over 7 years before President Ronald Reagan nominated Antonin Scalia to the Supreme Court back on July 7th of 1986. So Scalia was not yet a justice on the Supreme Court when he made those remarks. The next question we need to ask is, what was the full context of Scalia's remarks? The excerpt highlighted by COS and Senator Coburn is only a portion of what Scalia said. Scalia was answering a question asked by former ABC News chief John Charles Daly, who was moderating the forum. I'm going to read Daly's question along with Scalia's full response directly from the original transcript. Listen closely. John Charles Daly asks, "All right, Professor Scalia, Richard Revere in The New Yorker suggested that the convention method of amendment might reinstate segregation and even slavery, throw out much or all of the Bill of Rights, eliminate the 14th Amendment's due process clause, reverse any Supreme Court decision the members didn't like, and perhaps for good measure, eliminate the Supreme Court itself. Now, what would you anticipate from an unlimited convention?" Antonin Scalia, who was then a professor of law at the University of Chicago, replied, quote, "I suppose it might even pass a bill of attainder to hang Richard Revere. All these things are possible, I suppose, just as it is possible that the Congress tomorrow might pass a law abolishing Social Security as of the next day or eliminating Christmas. Such things are possible, remotely possible. I have no fear that such extreme proposals would come out of a constitutional convention. Surely whether that risk is sufficient to cause anyone to be opposed to a constitutional convention depends on how high we think the risk is and how necessary we think the convention is. If we thought the Congress were not necessary for any other purpose, the risk that it might abolish Social Security would probably be enough to tell its members to go home." So it really comes down to whether we think a constitutional convention is necessary. I think it is necessary for some purposes, and I am willing to accept what seems to me a minimal risk of intemperate action. The founders inserted this alternative method of obtaining constitutional amendments because they knew the Congress would be unwilling to give attention to many issues the people are concerned with, particularly those involving restrictions on the federal government's own power. The founders foresaw that, and they provided the convention as a remedy. If the only way to get that convention is to take this minimal risk, then it is a reasonable one. There you have it. The limited convention that Scalia favored in 1979, that both Senator Coburn and COS are promoting, was in fact a constitutional convention, as Scalia's own words indicated. Not only was Scalia talking about a constitutional convention, but the title of the American Enterprise Institute's hosted forum at which Scalia spoke and COS is quoting from was called, quote, "A constitutional convention, how well would it work?" The parts where Scalia specifically uses the phrase constitutional convention and the title of the forum are both conveniently omitted from COS's news article and emails. Why this omission? Because it doesn't follow the COS narrative that insists that a constitutional convention is a different creature entirely than an Article 5 convention for proposing amendments, or convention of the states as they call it. In 1979, both those who supported and opposed an Article 5 convention referred to it as a constitutional convention. In fact, Black's Law Dictionary makes no distinction between the two. defining constitutional convention with Article 5 of the Constitution as an example. The definition in Black's Law Dictionary reads, quote, "Constitutional convention, a duly constituted assembly of delegates or representatives of the people of a state or nation for the purpose of framing, revising, or amending its constitution." Article 5 of U.S. Constitution provides that a constitutional convention may be called on application of the legislatures of 2/3 of the states. This definition of a constitutional convention originates from the second edition of a law dictionary containing definitions of the terms and phrases of American and English jurisprudence, ancient and modern, published in 1910 by Henry Campbell Black himself, and it remains unchanged in contemporary editions of Black's Law Dictionary. Furthermore, at the start of the forum, moderator John Charles Daly said, and I quote directly from the 1979 transcript, quote, "30 states have now taken the extraordinary step of asking the Congress to call a constitutional convention. Article 5 of the Constitution states that if 2/3 of the states so petition, Congress, quote, shall call a convention for proposing amendments." That quotation from Article 5 provides the legal background for the expanding and complex conflict on how a constitutional convention would work. When Daly, Scalia, or the John Birch Society say the term constitutional convention, they mean the same thing as an Article 5 convention for proposing amendments, because it's the same thing as we've just established. Okay, you've made your point that both a constitutional convention and an Article 5 convention are the same thing. But what about Scalia? How does that change the fact that he supported a constitutional convention back in 1979? By 2014, now an associate justice on the Supreme Court for 28 years, Scalia changed his opinion about supporting an Article 5 constitutional convention. On April 17, 2014, Supreme Court Justices Scalia and Ruth Bader Ginsburg appeared on an episode of The Kalb Report, a one-on-one panel discussion, television, and radio program that's jointly produced by the National Press Club, Journalism Institute, and George Washington University. The subject of the program in which they both appeared was, quote, "a conversation about the First Amendment."
Justice Stevens recently suggested a constitutional amendment to modify the Second Amendment. If you could amend the Constitution in one way, what would it be and why? Justice Scalia.
I certainly would not want a constitutional convention. I mean, whoa. Who knows what would come out of that?
Later in 2015, during the Q&A session following a speech Scalia gave to the Federalist Society in Morristown, New Jersey, he was asked whether a constitutional convention would be in the nation's interests. Scalia replied, "A constitutional convention is a horrible idea," adding, quote, "This is not a good century to write a constitution." Scalia may have entertained the notion of an Article 5 convention back in 1979, but by 2014, he was firmly set against it, and rightly so, noting the uncertainty that could arise from such a modern convention. This is especially true given today's political climate and prevailing lack of education about the Constitution. The solution, as the John Birch Society advocates and Justice Scalia understood throughout his judicial career, is adhering to the Constitution, not changing it by way of amendments at an unpredictable convention.